Greetings, 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 greetings. It is I, your king, Clifford Jefferson, descendant of Godfrey, the fifth count of Anjou, son of folk ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which you call Jesus Christ. We are here today at the English Temple Church, amending of the English Temple of the English Church of England, which was went through a dissolution under the what we call the House of Tudor through King Henry VIII. We come to restore all that which was lost. We are here today amongst you, amongst the living, bringing back that that purified water, that's life-giving water that flows through our voice. For all those who are here today, we hold you accountable to what you hear today. As I always say, it's better for you to not know this than to know this and not follow it. I greet you as your king, and without further ado, I digress and let Queen Sister Godwin from the House of Godwin say a couple of words.
Greetings, greetings, greetings. Just want to say I give honors to the king and all our members here, all our countess, archbishop, all our nobles, earls, and brothers and sisters who are listening in. I just want to say to our listeners how imperative it is to teach our children their respective history. You don't want them going to these schools where they're teaching them somebody else's history. We have to instill it in our children. That's the only way we're going to get them on the right track. But it starts in the household. And with that, I digress.
Well said, Queen. I agree with that as well. And it starts from the youth. We just watching a movie on TV for our daughter, or will be my grandbaby, and it had a showing that going back into the days of pirate with a sister, for lack of a better term, Asiatic, on the pirate ship, and the main character in the story was Asiatic, for lack of a better term, little girl. So it just shows you how they put this history back in our face and catering to us and hoping we find the clues, because most of the clues go back into the days of piracy, whether you want to call them Vikings, because Vikings were pirates. Do we all agree?
Agreed.
Yes.
Agree. So it's very important we understand that, as our children right now, we want them to be children, and we want to listen to our children and communicate to our children on their level, because they're not on our level. So if we want them to learn and embrace our history, we have to give it to them on their level. So that way, when they get to our level, they'll be able to appreciate it and adapt and conform to it and become uniform with it as they express it throughout their daily lives, because why? It was instituted through the blood. So nothing that comes from the blood is unnatural to you. It should be natural. We just forgot it. So well said, Queen. Next, Archbishop.
Greetings, everyone, from the Kingdom of England, Empire of Albion. I, Archbishop Belmont from the Noble House of Belmont, give honors to our King as well as our Queen, our ancestors who have come and gone, who have left all of this information here for us to be able to recover during this day and time where we need it the most. And just like the King and Queen has said, we must be the ones that's teaching this information to our heirs, as well as those who don't know who they are. So therefore, we can actually reinstill peace back on planet Albion, or which we call Empire of England or Heaven on Earth. It's not going to be, an easy work, but everything is set up for us to be able to do what we need to be doing. So therefore, we can save the ones who are actually capable of being saved. Many are called, few are chosen. So with that being said, I digress and I leave the rest of the introduction to the rest of the congregation.
Well said, Archbishop. Brother Burgess from the House of Burgess.
Can you hear me?
Yes, we can hear you, Noble.
Can you hear me?
Yes, sir.
Hello?
Yeah, we can hear you.
My bad. It's on my greetings, family. Greetings, King, Queen, King's Bench, everybody that's watching. I always appreciate the fellowship and the communion. So I don't really have much to say. I'm just ready to get into it.
Well said. Short but sweet, like that. Next we have Countess Walker from the House of Walker. Greetings, Sister Walker from the House of Walker.
Greetings, greetings. I like to give honor to the King and the Queen, Archbishop Belmont and Archbishop CA and everybody here today. I was talking to a friend earlier, and sometimes in life we don't always get what we want, but sometimes it's what we need. And he was telling me he's a father, and I'm a mother, and we're sharing stories. And he told me today, he says, pain builds wisdom and pressure builds strength. So, sometimes we have some pressure and some pain, and, we find ourselves working through it so we can get more wisdom and more strength. And, I get a lot of wisdom every Sunday when I come to class. So I'm grateful to be here. Thank you.
Well said, Countess Walker. Like I said, wisdom, we all search for it and need it. But what is wisdom? That's the question. What is wisdom? Because a lot of people can't claim to have wisdom. Wisdom is its actual main focus is for guidance, right? That's the purpose of wisdom, it's to guide you. Mm-hmm. And in order for someone to guide you, there must be instructions set before you go on your quest. So the wisdom that you receive on your quest is based off the guidance that I'm giving you, taking you back to a time where I don't even go back to in the flesh. This is called time immemorial. And there's no need for confirmation, because the confirmation within the self is the truth. Truth don't need no confirmation. All right? Truth don't need no confirmation. It is what it is. We got to accept what's the truth. And only to know what's the truth, you have to be truth yourself. All right? So, well said. Countess Alice from the House of Alice. Greetings. Good morning.
Greetings, everyone. Greetings.
Lady Allen.
Great to be here today. Give honor to the King and to the Queen, Archbishop Belmont, C.A. Murphy, Brother Burgess, everyone that's on the panel. I look forward to this marvelous lesson today. We speak heavily about wisdom, and not everyone attains it. Even though you're here, you can spend an entire lifetime here in this earth plane and never gain all the lessons that are needed in life, which is why you end up coming back.
Yeah.
And with that, I look forward to this marvelous lesson today, because I know it's going to be powerful. Thank you. And
Well said. Good morning, CA. Good you was able to join us today, in light of your circumstances. Good morning, Noble.
Grand Rising, everyone. Grand Rising, King, Queen, King's Bench, Council, peace and love.
Good to have you, Noble. You came in right on time. You can give your introduction.
Greetings, peace and love, everyone. I trust all is well at the sound of my voice. Please forgive me for my tardiness and my lack of viewing. I am going to be sitting silent and listening to the lesson. And I'm looking forward to the marvelous lesson. And I'm also grateful to be in communion with my heirs and successors. So trust all is well, and I'll be gathering my notes and paying close attention.
Well said. Greetings. We're glad you was able to make it, brother, today. Brother Harris, greetings and welcome. Greetings. How you feeling today?
Greetings, my beautiful king and king. How you doing today?
All is well. How you feel?
The ancestors is strengthening me. I'm doing wonderful. I'll be out of for rehab soon.
Okay. We wish you a speedy recovery, Noble. It's like giving water to make the blind see in the lame walk.
That is
so
true.
That's what we do. And it's in the lifeblood. The lifeblood is in the word, and the word is the truth, and the truth is us. Why? Because we are the truth. So we're just glad you're here, and the spirit of the truth, because the spirit runs through all of us. So
to my English family, I just want to tell y'all I love you dearly.
Thank you. We hear that and we see that.
Thank you.
Right.
I digress.
Thank you, brother. Greetings, brother Greg from the House of Greg.
Greetings, King, greetings.
Greetings.
Greetings to the King, to the Queen, Archbishop, CA, Brother Burgess, and all the rest of who are tuning in. I'm just excited to get started with this lesson. I haven't been on here a long time, but man, the information that I'm receiving and going back over it later on and making notes and watching the videos, man, it's just amazing. We're blessed to be here. And if you're watching this right now, you're blessed to be here to see this. So I'm not going to take up all the time, but I just want everybody to know how important this message is and to pay close attention. And with that, I digress.
Well said, Brother Gray. Like I said, I come to clear out the cloudy, all the clouds in the sky. I come to make it a sunny day today with this lesson. And with that, I want to say greetings to Brother Scott from the House of Scott. Brother Means, you know I'm saving you for last, Noble. You know that. I like to hear you speak, brother, so I'm going to save you for last. Ain't no secret. Go ahead, Brother Scott from the House of Scott.
Greetings, everyone. Greetings, King. Greetings, Queen. Archbishop Belmont, CA, all the countesses, and all the brothers that are attending. Not much to say, King. I'm just looking forward to the life-changing information that we always receive. And once again, I really appreciate you for all that you do. I digress.
Well said, Brother Scott from the House of Scott. I appreciate each and every one of you just for giving me the ability to be who I am and the conscience that I am. You know, they say in the scripture that Jesus came to his own and his own received him not.
Audio for everybody.
Blessed are those who humble themselves for your salvation is with him. And like I said, our salvation, I have it now. It ain't something you got to wait to die for. We are already dead. Just trying to raise ourselves back to that unconscious state, to that live state of knowledge and wisdom comes from guidance, and from guidance comes pleasure. You know, so I'd rather be guided and pleasures from the truth than falsehood. So with that being said, I greet Brother Means from the House of Beings. It's always a pleasure to hear you speak, bro. I miss you on Sunday. You know, like I said, when you speak with passion. And everyone on this bench, you know, should look at not just you, but each and every one of us and our ability to be able to be passionate in that which we seek for the rest of the world, but not just ourselves. And this is what this panel is for, the world. Because we see we don't have the world in our thoughts, we have nothing for ourselves. And that's the way it was brought, and that's the way we receive it, and that's the way we give it. So greetings, Brother Means and House of Means. Good to have you here with us today.
Grand Rising to all, Grand Rising King and Queen. Excuse my little disoriented today. I'm working a little late, but it's always a marvelous opportunity to come before all of our illustrious family and relatives in lieu of our estate, being a nation to reclaim who we are and who our ancestors were, and be able to vividly see the comparison of law and legislation set before us to protect ourselves and spring forward our generations to come. It's a beautiful thing to actually say that we are family, and we are a nation, but we have legislation and law to back that up, to combine us as one, moving forward to this great war that's set before us without any bloodshed. The fact of the matter of being able to sit down under the tutelages of people of yourself, of the mind that you bring forth, and with the backing of substantial evidence to be able to, I guess, absorb and look at ourselves in the mirror and see our futures as beautiful and marvelous as the creation of old days. Again, I'm very honored to sit up under this meeting. I hate that I did miss the last meeting that you all have. Maybe I'll bring you up to speed. But Mr. Gray, like always, he keeps me informed. I digress.
Well said, well said. And I like the fact that last key you said, like a mirror, picture in the mirror. And that's symbolic of the movie of The Matrix, because the mirror is the legal fiction. That's our mirror for us. That's the matrix for us. That misunderstanding about legal person. A legal person is called an artificial person. That's our man in the mirror. And our job is to make sure that whatever we say, that man in the mirror do, and not the other way around. All right, I'm not gonna say that, but that's our job. You know, people even sung about it. I can say that much. But we dealing with the man in the mirror. Let's deal with this issue today, and that's that man in the mirror. All right, everybody ready? Let's go. All right, Bishop.
We got Brother Monday from the House of Monday.
Greetings, Brother Monday from the House of Monday. Greetings, we're able to join us today. How you feel today?
Greetings, Noble.
Greetings. Can't hear you, Noble. I'm man sweating for this information.
I don't think he know we're talking to him.
Brother Monday, can't hear you.
You hear us, Brother Monday?
We'll get back with you once
we
connect with you in the audio. All right, so once again, it's beautiful to see you all here today. You know, we online, all those who will be on the line, as the king, you know, I'm asking you, please don't take this lightly. Please don't. You know, we all look for someone to come back with an answer to solve our problems, to deal with our situation. Please, give me the benefit of the doubt. That's all I'm asking. Give me the benefit of the doubt. There's so many platforms out there today that are existing today, got hundreds, thousands of views. And I'm pretty sure each and every one of us, 9 times out of 10, hit those channels every once in a while, just to at least see a little bit of contrast. But within that contrast, raise some eyebrows. That's our job, is to rustle some feathers. When you look at the days of our ancestors and the days when they were being invaded, this is still what happened today, we're being invaded by Vikings. When I say Vikings, I mean those who not from here. You know, I'm not using it to calling people barbarians, but we're still in the days of the Vikings, where we're being invaded. We're being invaded by foreigners. And our obligation is to make sure that there's distinction between who is an alien and who's a citizen. We know a citizen and an alien in here in North America is synonymous. So we got to make sure we draw a distinction between that concept or that narrative in regards to a subject. Somebody said something?
No, that was just a feedback from the mic.
Okay, all right. So once again, welcome everybody. Brother Monday, can you hear us?
He can hear.
Yes.
Greetings, how you feeling today,
Peace
Noble?
and greetings.
Yeah, I was glad you
all
was
right.
able to make it today.
Yeah, I got a lot of financial issues, birthdays, family gatherings, family reunions, tests. I'm doing a lot, man. I'm trying to be great, so I got a lot going on, man.
I hear you. Glad you were able to make it.
I'm here today.
You know?
Peace and greetings, everybody. Peace and greetings. Yeah.
Well
Greetings,
said.
Brother Monday.
Well said. All right, well, let's get started. I know that we as our family are juggling a lot of things, you know, and that's where that joker comes from. You know, this deals with what we call commerce, trade, goods, and services. Very important word, commerce. The god of commerce is Hermes. Anybody know who Hermes was? The god Hermes?
He's the messenger of the gods, or known as the messenger of the gods.
He's the messenger of the gods. His symbol is Mercury. He's equivalent to Odin, Anubis, or Thoth in their creation stories. But our Archbishop said he was a message of God. All right? Now we know that the messengers of God were the angelic beings, which we are the messengers of God. Why? Because we are natural people. We are human beings. Natural people are not here for capitalism or merchantism, which they call commerce, because our land is allodial. It belongs to us. Under the public trust doctrine, we got the right to all the natural resources of what the land provides for us, right? So there's no need to do commerce. Why? Because there's nothing to trade for. It's ours. It's free for us to have. But somehow the word of the term commerce came into the picture. This is called feudalism. Feudalism brings forth feudal tenures, which creates what we call feudal money. And the concept of that draws its origin from what we call fee and simple, which is contrast to allodial. You got fee and simple, you got allodial. The land is allodial, no longer feudal simple. Why? Because of one thing, the concession agreement of 1664 with George Carteret and John Berkeley. Before it was called New Jersey, the symbolic flag that was flying for this territory was the flag flying behind each and every one of you on this podcast today. Do y'all hear me?
I'm listening, King.
It's called Belwick of Jersey. This land could form of East Jersey and West Jersey, which was under the territory jurisdiction of what we call the monarchs of the British Empire, which starts with Queen Anne. 1702, George Carteret and John Berkeley surrendered the territory called East Jersey and West Jersey back to the Crown. And United States is what? Successor to the Crown versus United States versus Juan Kim Art. We've already been through this. It's in the podcast on each and every lecture that we did recently. So all those who sit here on this podcast don't understand what the king's saying, then you better hope I don't ask no questions, because y'all should know this, because you are members of the king's bench. All right, so I'm not gonna put nobody on blast, but today's lesson is very important to understand how important you are, because from this point on, I'm checking everybody. I'm checking each and every one of you, because this is no secret to the world. How we know that? Let's look at it. First, let's start here. We've already been through this case already. The United States is Juan Kim Art. Read these two right here from his sister Walker from the House of Walker. This is Juan Kim Art. First, before we read that, let's revisit what we already been talked about in our last classes. Because there's nothing new.
In Dred Scott versus
Not yet.
Sanford.
Let me go. I want to do something first. In our last class, for all those who are doing this podcast, we went over this right here. This deal with the term natural born citizen. Natural born citizen, the Constitution does not expressly define natural born, nor has the Supreme Court ever ruled precisely upon its meaning. One can be a citizen while not being a natural born citizen. For example, that person gains citizenship through the process of naturalization. The 14th Amendment Naturalization Clause and Supreme Court case United States versus Juan Kim Art, which I just stated, states that anybody born on United States soil and subject to its jurisdiction is a natural born citizen, regardless of parental citizenship. This type of citizenship is referred to here in the United States as birthright citizenship. Birthright citizenship. Those who are viewing this podcast, who are not on this King's Bench, y'all better listen to what I'm telling you. Under the Supreme Court, United States versus One Kim Ark, they classify citizens here in the United States, as well as the states as natural born citizens. And this is what determines your birthright citizenship under the 14th Amendment of the United States clause. I didn't say it, it's right there. Everybody agree?
Agreed.
Agree.
It's set under Title 8 United States Code, Section 1101 defines naturalization as conferring of nationality. So to them in the United States, naturalization is nationality. We're not making this personal, brothers and sisters. This is not personal. We're talking about nationality, birthright, because to them, naturalization is a birthright. That's not substantive in nature because there's no rights protected in lieu of naturalization, which they call a birthright in the United States, because you are considered an alien. How I know that? Let's look at this. Yeah. What was the ad just a second ago? Oh yeah. No. What would you read it from, Sister Walker? What was at Crown Colony? We was on something.
Natural born citizen.
Natural.
Oh, we was on, okay. No, something else.
One
before I
Kim Ark.
clicked there.
Yeah, walking
It
on.
was, Dred
What was
Scott.
that?
Dred
U.S.
Scott.
versus One Kim Ark.
Oh, okay, yeah, One Kim Ark. Okay, that's right. Okay. All right, so this is One Kim Ark, everybody. This is One Kim Ark, the one Supreme Court case that they use to determine citizenship here in North America. And they said that citizenship was called naturalization, which to them is called naturalization, which is what they call a birthright. Has nothing to do with blood. That's just so. Now, under Dred Scott, under United States versus One Kim Ark, the case make reference to Dred Scott versus Stanford. And read what it says, Sister Walker. Who was reading? Sister Walker?
In Dred Scott versus Sanford, Mr. Justice Curtis said the first section of the second article of the Constitution uses the language, a natural born citizen, in thus assuming that citizenship may be acquired by birth. Undoubtedly, this language of the Constitution was used in reference to that principle of public law, well understood in this country at the time of the adoption of the Constitution, which referred citizenship to the place of birth.
Pay close attention to that word, place of birth. Citizenship, continue.
And to this extent, no different opinion was expressed or intimidated by any other judges. In United States versus Rhodes, Mr. Justice Swain, sitting in the circuit court, said, all persons born in the allegiance of the king are natural born subjects, and all persons born in the allegiance of the United States are natural born citizens. Birth and allegiance go together. Such is the rule of the common law. And it is the common law of this country as well as England.
Stop right there. Okay. So now they're telling you in Supreme Court case that in United States versus Rhodes, that if you're a citizen of the king, then you are a subject. If you're a citizen of the United States, then you're a citizen. So if you're a citizen of the United States, that means you're a naturalized citizen, which they call national, which to them is called a birthright. See the difference? But the birthright for us as subjects of the king, as they stated in United States versus Roe, is a birthright as well. All persons born in the allegiance of the king are natural born subjects. All persons born in the allegiance of the United States are natural born citizens, because birth and allegiance go together. Such is the rule of the common law, and it's the common law of the country as well as in England. So they tell you it's the common law of the United States as well as the common law of England, that in England, you're a subject. In the United States, you are a citizen. And they make a reference to citizen by way of natural born citizen under the 14th Amendment as established in the United States versus One Kim Art, which you're reading right now. And they reference the Dred Scott case. We just read it. They just referenced the Dred Scott case. So, like I said, this ain't nothing new to them. How I know that? Let's read on a little bit more. This case, we already been through this case. Continue to read.
Okay. You went down a little too far. I got to get the last sentence.
Get that last sentence. You said, I ain't get the last sentence. That's what I'm talking about.
Such is the rule of the common law, and it is the common law of this country as well as England. We find no warrant for the opinion, and that this great principle.
I'm sorry. Okay.
This great principle of the common law has even been changed in the United States. It has always obtained here with the same vigor and subject only to the same exceptions, since as before the Revolution.
Oh, that's good. That's good. Okay. So they make a reference to the common law as well as the distinction between a citizen and a subject here in what we call England as well as the United States, because the United States adopted the common law. How we know that? United States versus One Kim of Art. This is the case we're reading. Everybody see it. Let's go ahead and read in versus Bowden. This is reading versus Bowden, but they make reference to the same case. Read what it says, Sister Walker.
The very learned and useful opinion of Justice Gray, speaking for the court in United States versus Wong Kim Ark, establishes that at common law in England and the United States, the rule with respect to nationality was that of jus soli, that birth within the limits of the jurisdiction of the crown, and the United States as the successor of the crown, fixed nationality, and that there could be no change in this rule of law except by statute, and that by the statute of Queen of 7 Anne, extended by the statute of 4 George II, all children born out of the lineage of the allegiance of the crown of England, whose fathers were or should be natural born subjects of the crown of England or of Great Britain at the time of the birth of such children, respectively, were deemed natural born subjects of that kingdom to all intents and purposes whatsoever.
That's cool. That's cool. That's cool. All right. So we just seen, based off the case that decided the difference between a subject and a citizen, that one case determined the difference between a citizen and a subject. If you're a citizen, then you automatically fall in the category of the United States citizen. If you're a subject, then you fall in the jurisdiction of the king. That makes sense?
Makes a lot of sense.
With that one case. All right. Now, this is important. Why? Because this all deals with nationality. It just said under the United States that under Title 14th Amendment that citizenship in the United States is concerned with naturalization, right? And that's a birthright. But nationality to the king, you're a subject, which is also a birthright too as well. So now we got to decide which one we want. Are we going to be citizens and have the birthright as a status for naturalized citizens who are really what we call citizens? We already been through this. This is nothing new. I just brought it back up for review. We ain't just making stuff up. Read that, Sister Walker.
Okay, denization is an obsolete or defunct process in England and Ireland and the latter Kingdom of Great Britain, the United Kingdom, and British Empire dating back to the 13th century, by which an alien, a foreigner, through letters patent became a denizen, thereby obtaining certain rights otherwise normally enjoyed only by the king's or queen's subjects, including the right to hold land. The denizen was neither a subject with citizenship or nationality, nor an alien, but had a status akin to permanent residency today. While one could become a subject via naturalization, this required a private act of parliament or laterally of a colonial legislature. In contrast, denization was cheaper, quicker, and simpler.
That's fine. That's fine. Okay, so it says, while one can become a subject via naturalization, this required a private act of parliament or laterally of the colonial legislator. Now you're talking about the colonial legislator in regard to naturalization. Now follow me, y'all. Follow where I'm going with this. Diversity of citizenship. We already been through this. I just want a clearer understand for us to understand the situation we're in. Read this, Sister Walker.
Okay, diversity of parties. Mostly, in order for diversity jurisdiction to apply, complete diversity is required, where none of the plaintiffs can be from the same state as any of the defendants. A corporation is treated as a citizen of the state in which it is incorporated, and that the state in which its principal place of business is located. A partnership or limited liability company is considered to have citizenship of all of its constituent partners / members. Thus, an LLC or partnership with one member or partner sharing citizenship with an opposing party will destroy diversity of jurisdiction. Cities and towns, incorporated municipalities are also treated as citizens of the state in which they are located, but states themselves are not considered citizens for the purpose of diversity. US citizens are citizens of the state in which they are domiciled, which is the last state in which they resided and had an intent to remain.
That right there. So why can't states be considered for diversity of citizenship, Sister Walker from the House of Walker?
Because the businesses and the corporations are incorporated in that state. The state is their parent.
That's what I'm talking about. That's what I'm talking about. Learn. All right, we can move forward. All right, so we know that there's a diversity issue because on the case law, they got that a corporation can be a citizen of the state where its place of local business is located. There's like a limited liability partnership, as well as incorporated cities and municipalities. And we're not citizens of any of those classifications. So there's a diversity issue. Why? Because upon place of birth determines your birthright. Didn't it say that?
Mhm.
Now, according to where you're born, determines your birthright, and that's how personal jurisdiction is established because of that word, legal person. Because it just said corporations can be citizens. So that only brings you up to the term legal person or juridic person. Bring this here. And I'm pretty sure once in our life we came across this definition in Wikipedia. Now, I know that because I've done it. Remember, clarity didn't come till now. Read what it says. Sister Walker.
Okay, in law, a legal person is any person or thing, less ambiguously, any legal entity that can do the things a human person is usually able to do in law, such as enter contracts, sue and be sued, own property, and so on. The reason for the term legal person is that some legal persons are not people. Companies and corporations are persons legally speaking. They can legally do most of the things an ordinary person can do, but they are not people in a literal sense.
You gotta hear that. Listen to what they telling you.
Yes.
This has been our issue right here. Continue to read.
There are therefore two kinds of legal entities, a human and a non-human. In law, a human person is called a natural person, sometimes also a physical person. And a non-human person is called a juridical person. Juridical person, sometimes a juristic, artificial, legal, or fictitious person. Juridical persons are entities such as corporations, firms, and in some jurisdictions and many government agencies. They are treated in law as if they were persons, while natural persons acquire legal personality naturally simply by being born, or before that in some jurisdictions. Juridical persons must have legal personality conferred on them by some unnatural legal process, and it is for this reason they are sometimes called artificial persons. And
read that again. Read that again. That's powerful.
Juridical persons must have legal personality conferred on them by some unnatural legal process. And it is for this reason they are sometimes called artificial persons. In the most common sense, incorporating a legal business, legal personality is usually acquired by registration with a government agency set up for the purpose.
Read it again.
Incorporating a business, legal personality is usually acquired by registration with a government agency set up for the purpose.
Okay, so registration set up for a legal person is done by registration into a corporation, which is actually conferred on them by way of being born in that jurisdiction, as you just said, by some unnatural or some unlawful process. Didn't it just say that?
Yep.
And they made the distinction between a natural person, i.e. human being, or physical person, versus a legal person, which is the juridic, artificial, or straw man, etc. Whatever your name come from, that makes a diversity issue as a result of the your status as a human being, and you have a nationality. 1 second, y'all.
Point of entry.
Yeah, so go ahead, Archbishop.
That's that articles of incorporation we was already speaking about. And as we see, just like we proved with the birth certificate, it's not just coming from the so-called state or city, it's actually coming from the municipality. And the municipality are nothing more than incorporated artificial persons. So ask yourself, how can an incorporated artificial person give natural people rights? How can an artificial incorporated person even deal with natural real people?
Right.
1 second, Archbishop. I want to send the email and send it out to my daughter.
Okay.
1 second. Okay. All right. So as we can see, there's a difference between a natural person and juridic person. And it says a natural person and juridic person can do pretty much the same thing, but there is a difference, right? Because it said a legal personality must be conferred on that person. And the person is very distinct. Why? Because you know, as citizens, citizen is an artificial person or naturalized citizen, which they call national, which is considered a birthright, versus that which comes from England, which denotes to a subject. which means that you're under the jurisdiction of the king. Now, that's called an abstract title. All right, hold on 1 second. All right, so let's get busy. Let's qualify this. Read right here, and as legal.
Oh, as legal personality is a prerequisite to legal capacity. The ability of any legal person to amend, i.e. enter in, transfer, etc., rights and obligations. It is a prerequisite for an international organization to be able to sign international treaties in its own name. The legal person can be ambiguous because it is often used as a synonym for terms that refer only to non-human legal entities, specifically into contradictions to natural persons.
Okay, now, most of the time you hear this argument in forums that's not in courtroom. It ain't like this the first time you heard this information about artificial people, but where do you raise this argument at in regard to the diversity issue, in regard to artificial person, which is clear you got me classified as, based off a citizen being naturalized under the 14th Amendment, which most 99.9% all citizens fall in that category. Which Dred Scott didn't even have that privilege because even though he was freed by the 13th Amendment, he didn't have no protection under the citizenship, under the Constitution. All right. Let's go right here. Read this right quick. Let's read a little quicker for me if you don't mind.
All right. Artificial personalities, jurisdictional personalities, or juristic personality is the characteristics of a non-living entity regarded by law as having status of personshiphood. A jurisdictional or artificial person has a legal name and has certain rights, protections, privileges, responsibilities, and liabilities in law, similar to those of a natural person. The concept of a jurisdictional person is a fundamental legal fiction. It is pertinent to the physiology of law as it is essential to laws affecting a corporation laws.
Right there, that's it right there. Now let's go now. Now let's keep giving you an argument based off philosophy or the concept of what they call an artificial person, but there's no connection to a legal argument making the distinction, which people have failed to do. Why? Because they're not taught the legal aspects of the subjectivity of what the status of what we call artificial person. That's what our job is to uncover, and we're uncovering it. Why? Because let's look at the legal ramifications. Now it says right here, one of the examples, municipal. Didn't it say that? One example, the municipal corporation are creatures of the statute. That's what it said. Municipality is another example of a legal person, which is nothing more than a creature of the state. Let's move down. Unincorporated associations, partnerships, companies, you see all these. Trade unions, unlimited corporate companies, trusts, funds, limited liability companies, private companies, limited by guarantee, private companies, limited by share, public limited companies, blase, blase. All right. Now this is very important, the history. Start from here and your closing right here.
Okay, in the common law tradition, only a person can possess legal rights. To allow them to function, the legal personality of a corporation was established to include the 5 legal rights: the right to a common treasury or chest, including the right to own property, the right to a corporate seal, the right to make and sign contracts, the right to sue and be sued, to enforce contracts, the right to hire agents, employees, and the right to make bylaws, self-governance.
Now what that sound like?
Municipal corporation.
They just tell you the qualifications that meet the standard of what they call a legal person. And we meet that as well, but we're not a legal person. We're a corporation sole. How we know that? Because that legal fiction or corporation aggregate is just a bunch of people coming together as corporation versus a corporation sole. A corporation sole is a natural person and a corporation at the same time. Mm-hmm. And when I incorporated you as agency employees, y'all were incorporated as natural persons as well, fulfilling a corporate activity or a corporate tenure or a corporate status, a fiduciary office. But that's natural people. That's the only way we can be protected. Because it is said in common law, only a person can possess legal rights. To allow them to function, the legal person of a corporation was established to include 5 legal rights: common treasury, i.e. Department of Treasury, the right to include property, the right to have a corporate sale, the right to sue, this contract law. All right, let's go down a little further.
Point of interest, and the key that it said was self-governance. So if it's self-governance, that's your government. Same way how we have done with the church, which is a self-governing body. That is your government. It's the church.
Mm-hmm. All right, that's what I need here. 1 second. So I just spoke about common law. In common law, a person has the right to own property. Now, property can't own property. Ain't that the case?
Correct.
Yes.
Property can't own property. Now, let's really get undercover in regards to the status of a legal person. Now, we know the difference between diversity, and now we know the difference between legal person. Now, why is this very important? Why? Because it said a municipality is also a legal person, didn't it?
Yes.
All right. So let's go here to what we call Thomas versus Zerk. No, Ohio versus Independence. Sister Walker, you can read from there.
Me or Sister Allen?
Sister Allen, I'm sorry, Sister Allen. 1 second.
Right there?
Right there.
Owen versus the City of Independence. After the City Council of Respondent, city moved that reports of an investigation of the City Police Department be released to the news media and turned over to the prosecutor for presentation to the grand jury, and that the city manager take appropriate action against the persons involved in the wrongful activities brought out in the investigative reports. The city manager discharged petitioner from his position as chief of police. No reason was given for the dismissal, and petitioner received only a written notice stating that the dismissal was made pursuant to a specific provision of the city charter. Subsequently, petitioner brought suit in federal district court under 42 U.S.C. subsection 1983 against the city, the respondent city manager, and the respondent members of the city council in their official capacities, alleging that he was discharged without notice of reasons and without a hearing, in violation of his constitutional rights to procedural and substantive due process, and seeking declaratory and injunctive relief. The district court, after a bench trial, entered judgment for respondent. The Court of Appeals ultimately affirmed, holding that although the city had violated petitioner's rights under the 14th Amendment, nevertheless, all the respondents, including the city, were entitled to qualified immunity from liability based on the good faith of the city officials involved.
Stop right there. Okay. So this is a case, Owen versus City Independence, in regards to violation of Title 24, Section 1983 of the United States Code. And it's in regards to an officer complaining about another officer who worked for the city. All right, in regards to substantial rights under what they call privileges and immunities protected by the state constitution. Now look what the court ruled in regards to both parties, because one party worked for the city but was suing the city in regards to violation of due process of law. Because Title 24 United States Code 1983 deals with deprivation under the color law of the state. Everybody hear me?
Follow.
Deprivation of right under the color law of the state. Read what the case, what the court held. Go ahead, Sister Allen.
Held.
Oh, I'm sorry, 1 second.
Okay.
Go ahead.
Held. A municipality has no immunity from liability under subsection 1983, flowing from its constitutional violation, and may not assert the good faith of its officers as a defense to such liability. By its terms, subsection 1983 creates a species of tort liability that, on its face, admits of no immunity. Imbler versus Packman. Its language is absolute and unqualified, and no mention is made of any privileges, immunities, or defenses that may be asserted. Rather, the statute imposes liability upon every person held in Monell versus New York City Department of Social Services to encompass municipal and corporations who, under color of state law or custom, subject or causes to be subjected any citizen of the United States to the deprivation of any rights, privileges, or immunity secured by the Constitution and law. And this expansive suite subsection 1983's language is confirmed by its legislative history, where an immunity was well established at common law and where its rationale was compatible with the purpose of subsection 1983, the statute has been construed to incorporate that immunity. But there is no tradition of immunity for municipal corporations, and neither history nor policy supports a construct of subsection 1983 that would justify the qualified immunity accorded respondent city by the Court of Appeals. The application and rationale underlying both the doctrine whereby a municipality was held immune from tort liability with respect to its governmental functions, but not for its proprietary functions, and the doctrine whereby a municipality was immunized for its discretionary or legislative ability activities, but not for those which were ministerial in nature, demonstrate that neither of those common law doctrines could have been intended to limit a municipality's liability under subsection 1983. The principle of sovereign immunity, from which a municipality's immunity for governmental functions derives, cannot serve as the basis for the qualified privilege respondent claims under subsection 1983. Since sovereign immunity insulates a municipality from unconsented suits altogether, the presence or absence of good faith being irrelevant, and since the municipality's governmental immunity is abrogated by the sovereign's enactment of a statute such as subsection 1983, making it amendable to suit, and the doctrine granting a municipality immunity for discretionary functions, which doctrine merely prevented courts from substituting their own judgment on matters within the law discretion of the municipality, cannot serve as the foundation for a good faith immunity under subsection 1983, since a municipality has no discretion to violate the federal constitution.
Okay, so majority of the time, most of, as we said, encounters we have is with the municipality.
Mhm.
And it just said that the municipality has no right to violate what you told me. Yeah, she's there. She's there. Everybody say good morning to my daughter.
Greetings, Princess China Jefferson.
She said she ain't saying nothing, but she listening. That's good enough. All right. So it's very important to understand in regards to government immunity in lieu of municipalities. It just said that the municipalities don't have any immunity, nor are they established based off good faith. Why? Because they're not using state law. They're using color law of the state. Why? Because they go by municipal ordinances. So most of the encounters we have as citizens is a result of the classification of citizen because of the identity of a legal person. And the identity of a legal person is established based off you're being born in a particular jurisdiction. And the jurisdiction that they're saying you're being born of is a municipality. So they just violate your rights. How we know that? Let's look up here. Because we know that citizenship is based off incorporation.
Mm-hmm.
It just said based off diversity that a corporation can have the same citizenship of its constituent corporation and the state where they're incorporated and their local place of business. Just like partnerships, limited liability companies, corporations, firms, partnerships, etc. Just as well as cities and municipalities. But now we're reading here in Owen versus City of Independence that municipalities are acting outside the state legislation. Why? Because they're in violation of Title 24, Section 1983, in lieu of declaration of rights under color of law or color of statute. How we know that? Let's look what the legislation say. Where is it at? I think I said it. Let's look at another case. Paul versus Virginia. Read the Sister Allen.
Paul versus Virginia. Can you blow it up a little bit bigger?
I'm sorry. Yes, I got you. How's that?
Yes. A state statute which enacts that no insurance company not incorporated under the laws of the state passing the statute.
Sorry.
Okay.
Is that it?
Yes. Passing the statute shall carry on its business within the state without previously obtaining a license for that purpose, and that it shall not receive such license until it has deposited with the treasurer of the state bonds of a specified character to an amount varying from $30,000 to $50,000 according to the extent of the capital employed, is not in conflict with that clause of the Constitution of the United States, which declares that the citizens of the state shall be entitled to all the privileges and immunities of citizens in the several states, nor with the clause which declares that Congress shall have power to regulate commerce with foreign nations and among the several states.
Stop right there. Okay. Now they're dealing with citizens and commerce. In this case, they're talking about citizens and commerce. Now we already established the different types of citizens because they said corporations can be citizens, partnerships, limited liabilities can be citizens, municipalities, big villages, bureaus, Dunkin' Donuts, the thrift shop, the YMCA, any place that you have a relationship, i.e. a contract with, gives you privileges and immunities that the rest of the citizens cannot have if you're not registered with them. So even though you might be a citizen of the state, if you're not registered with the YMCA, like another person is in YMCA, you don't have the right to the privileges, even though you're a citizen. You see? All right, now let's see what this case says about citizenship. 1. Hold on, let's go to 2. All right, 2.
Corporations are not citizens within the meaning of the first of these clauses. They are creatures of local law and have not even an absolute right of recognition in other states, but depend for that and for the enforcement of their contracts upon the assent of those states, which may be given accordingly on such terms as they please.
Stop. Okay, so you read the case law in 1869 that said that corporations are not citizens, right? We just read Owens versus the City of Independence that said municipalities are practicing color of law. Why? Because they're acting out laws that they created for themselves and not the laws of the state. Because the laws of the state, which you're reading based off state legislation coded by case law, just said that corporations are not citizens and municipalities are corporations.
Mhm.
So if municipalities are corporations and that corporations are not citizens, then based off what you just said in Owen versus City of Independence, they can be held liable. And they can be held under Title 24, United States Code, Section 19, what was it, 1983, for deprivation of rights under color of law. So since we're reading that Paul versus Virginia said corporations are not citizens, they are making a clear distinction between who is a citizen.
Mhm.
A corporation, i.e. a juristic person, i.e. Artificial person, i.e. a straw man, is not the same as a citizen, i.e. a natural person or a human being or a physical person. Totally distinction is being made with this case here in 1869. You see that? Continue to read.
Number 3. Okay. Number 3, the privileges and immunities secured to citizens of each state and the several states by this clause are those privileges and immunities which are common to the citizens in the latter states under their constitution and laws by virtue of their being citizens. Special privileges enjoyed by citizens in their own states are not secured by it in other states. Number 4, the issuing of a policy of insurance is not a transaction of commerce within the meaning of the latter of the two clauses, even though the parties be domiciled in different states, but is a simple contract of indemnity against loss.
All right, stop right there. So this case right here is making a distinction between a corporation and a citizen. Now, this case was overruled by Supreme Court right here. All right, anyhow, this case was overruled in regards to the Commerce Clause. Commerce Clause is operating on Article 1, Section 8. That's the Commerce Clause. All right. Now, in this clause, it just made the distinction between a corporation or not citizens. But for the sake of commerce, citizens can be, corporations can be citizens. I'm gonna say it again. In lieu of citizenship, a corporation cannot be a citizen. It just said it here.
Mhm.
Right? It just said it here. But for the sake of commerce, a corporation can be a citizen. We just go right back here. Thomas, we'll do that again.
That the people been dealing with.
Let's read it. Zicki versus Thomas versus Zicki. That's not it. Where is it at? Right. Read this case. Sister Allen.
Opinion and order. Philip Simon, District Judge. Sunshine Thompson, a prisoner confined at the Danbury FCI, filed a complaint pursuant to 42 USC subsection 1983, alleging that attorney Tony Zirkle overcharged him for his legal services. Pursuant to 28 USC subsection 1915, the court must review the merits of a prisoner complaint and dismiss it if the action is frivolous and malicious, fails to state a claim upon which relief may be granted, or seeks monetary relief against a defendant who is immune from such relief. FED or CIV. provides for
That's federal civil rules of procedures, motion to dismiss, 12B6. They call it a 12B6. That's the language they
Okay.
use in federal courts. All right, go ahead.
provides for the dismissal of a complaint or any portion of a complaint for failure to state a claim upon which relief can be granted. Courts apply the same standard under subsection 1915A as when addressing a motion under Rule 12B6. Lagerstrom versus Kingston. A claim may be dismissed only if it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. Allegations of a pro se complaint are held to less stringent standards than formal pleadings drafted by lawyers. Accordingly, pro se complaints are liberally construed. In order to state a cause of action under 42 U.S.C. subsection 1983, the Supreme Court requires only two elements. First, the plaintiff must allege that some person has deprived him of a federal right. Second, he must allege that the person who has deprived him of the right acted under color of state law.
Read that paragraph again.
The Supreme Court requires only two elements. First, the plaintiff must allege that some person has deprived him of a federal right. Second, he must allege that the person who has deprived him of that right acted under color of state law.
Now stop right there. Now, if you look at the parties in this matter, the plaintiff's case got dismissed on one condition as a result of him participating in what we call commerce. This wasn't an issue dealing with his citizenship of deprivation of rights under color law because of his nationality. It was the deprivation of the privileges and immunities that are protected under Title 42 United States Code 1983 under color of the law. He wasn't acting under color law of the state. This was a state issue, not a municipal issue. But as we just read in Owen versus City of Independence, that the municipalities are subject to limited liability under the tort clauses because they don't have any immunities in lieu of Title 42 United States Code 1983, deprivation of the color law of the state. Because the municipality laws are not laws of the state. Does that make sense to everybody?
Follow.
Yes, yes.
You're not a citizen of the municipality. You're not a citizen of the city. You're not even a citizen of the state. Because we just read in the diversity issue that states cannot be considered for diversity. Why? Because only those who are incorporated in the state can be considered for the diversity issues. And that's based off their certificate of incorporations. And that's based off companies.
Yep.
But in this case, you see that the parties got the plaintiff said that the defendant, the attorney charged her too much money. And that was a violation of his privileges and immunities in regards to due process of law of a deprivation of rights. That's not an issue. Why? Because you're considered a citizen of that state. And he was using laws of the state. Even though the laws of the state were colored too, it didn't make a difference to him because of his citizenship as based off him being subject to the municipality where those laws originated from. Because we just read under here in Owen versus City, where it's dealt with the same statute section, Title 42, United States Code 1943. It says that where immunity was established at common law and where its rationale was compatible with the purpose of Section 1983, the statute has been construed to incorporate that immunity. But there is no tradition of immunity from the municipal corporation, and neither history nor policy supports a construction of the remedy provided under Section 1983 that would justify the qualified immunity according to respondent city and the Court of Appeals. They appealed it, but they still said that no immunity could be, that they can't hold them, the city are not considered subject to the immunity clause as established under Section 1983 because the city or the municipality was a corporation. And the corporation was not a citizen as construed in Paul versus Virginia. right there. Corporations are not citizens, but in the meaning of the first clause. The only way they can be citizens are for the purpose of what we call commerce. That makes sense. So if your citizenship is under the United States by way of naturalization, then guess what? That's based off commerce. Let's get to the nitty-gritty. Let's go to the Constitution. First here, Crown Colony. All right, brother Means, you can read here.
All right. Crown Colony. A crown colony or royal colony was a colony administered by the crown within the British Empire. There was usually a governor appointed by the monarch of the UK on the advice of the home UK government, with or without the assistance of local council. In some
Stop
cases,
right there. Stop right
okay.
there. So it said the crown colony or royal colony was a colony administered by the crown. And let's go back to United versus Juan Kim Mark. Or Whedon versus Chimbao, either one. It just stated in Juan Kim Ark, it says that the very learned and useful opinion of Justice Gray, speaker for the court of the United States versus Juan Kim Ark, established that at common law in England and United States, the rule with respect to nationality was that of just so, and that birth within the limits of the jurisdiction of the crown and the United States as successor of the crown was fixed to nationality. Now, this is a Supreme Court case. Now we're going back to crown colony because we know what the crown is, United States. That makes sense, everybody?
Yes.
The crown is the United States. So now if the crown is the United States and we're talking about the colonies on the crown, which is right here, it says that the crown colony or the royal colony was a colony administered by the crown. Just a recap, was the crown?
United States.
A corporation sold.
Mm-hmm.
Here you go. This is the crown. A corporation sold. The crown is the legal embodiment of executive, legislative, and judicial government in the monarchy of each Commonwealth realm. These monarchies are unified by the personal union of their monarch, but they are independent states. The concept of the crown developed first in England as the separation of the literal crown and property of the kingdom from the personal property of the monarch. Now let's go back to crown colony. Crown colony or royal colony was a colony administered by the crown, i.e. the corporation sold. We incorporated as a corporation sold, represented by the crown. So we represented by the crown by way of our certificate of incorporation, just like everybody else who incorporated by way of their certificate of incorporation, which determines their citizenship.
Mm-hmm.
Right? Because corporations could have citizenship and do a diversity issue. So it's clearly a diversity issue between us versus the other citizens in lieu of their certificate of incorporation. Because on our certificate of incorporation, it says the crown.
Right.
Exactly.
And the crown covers what? The crown colony.
Land.
All right, i.e. crown land. Let's go back to the crown. It says the term also found in various expressions such as crown land, which some countries refer to public land, state land, as well as some office such as Minister of the Crown, Crown Attorney, or Crown Prosecutor. So the crown represents the government, the executive, legislative, and judicial branch. And at this time, it was being ran when you had colonies, as we're reading now. Everybody see that?
Yes.
Mm-hmm.
And the head of that crown colony was who? The governor.
Governor.
All right, now we can move further. Avalon Constitution. Constitution of New Jersey, 1776. The reception statute or the nullification provision clause states here that in lieu of this charter, i.e. Constitution, it said that the true intent and meaning of Congress that if a reconciliation between Great Britain and these colonies should take place and the latter be taken under the protection of the government of the Crown. Greetings, Sister Harris from the House of Harris.
Greetings, Sister Harris from the House of Harris.
Greetings.
Greetings. We missed you on the last couple of days. Where you been hiding?
Oh, I had a funeral to go to last week, and then this week I just came back from the country. I was trying to get here in time to be on the camera, so my
Okay, all
apologies.
right. We know we're gonna put you on blast now. Good to have you.
No
All
problem,
right.
no worries.
We're not upset that you weren't able to view the opening of the podcast, but you'll be able to review it once it's being posted. So we actually reviewing what was I said the topic was. What was that topic I said? I gotta help me out. Oh, looking in the mirror.
Looking in the mirror.
We're looking in the mirror. Who is the woman or the man in the mirror that you see? And what I'm telling you, what you see in that mirror is the legal person. And a legal person is distinct from a natural person. A legal person is an artificial construct known as a citizen or an alien, which was given what they call a letter patent, which is a form of citizenship. And a natural person is a person who's born on the soil, but by blood, who has a birthright here, denoting to what we call hereditaments. Now we're showing you, or what I'm going to show you here, is that those who were considered citizens by way of naturalization, and naturalization is what the United States call nationals, which is what they call a birthright. That came through what we call the Naturalization Act of 1790.
Mm-hmm.
Before that Naturalization Act, you had the Plantation Act or the Naturalization Act of 1740.
Yep.
That dealt with the colonies who were to inhabit the American colonies that we're talking about right now called Crown colonies. Because the Crown colonies were under the authority of the Crown. The Crown was a corporation sold, and the Crown covers the Crown lands, and we just read based off United States versus Juan Kim Ark that the United States was the successor to the Crown, and this fits the nationality. But nationality in the United States is based off naturalization by you being born in the soil. Had nothing to do with the blood, called just sanguineous. Because the birthright dealing with the blood is for the heirs that goes back to the original grant given by the Crown, which we're talking about the corporation sold, which we were incorporated in the state, because it's a citizenship as determined by your certificate of incorporation. So when we incorporated in the state, not saying we incorporate in the state, but we just incorporated in the state so we can be protected by the laws of the state, just as well as the laws of the United States will protect all citizens under Title 42 United States Code, Section 1983, which we just read in Owen versus City of Independence. All right. So now we're saying that the true intentions of the General Assembly of New Jersey State Legislature when they declared their independence in 1776. Prior to that independence, they were a part of what? The Crown. Because George Carteret and John Berkeley, who split up Jersey, then called it East Jersey and West Jersey, surrendered it back to the Crown in 1702. Right? But in 1776, when Queen Anne passed it to King George I in 1714, it was being passed to what they call the House of Handover. So as a result of what those monarchs that was doing at the House of Handover, King George I, King George II, King George III, they were part of a corporation called the Sea Bubble Company. Let's hit that real quick. We already talked about that in prior lessons, but let's revisit it. Right. I thought I had that shown up on here.
We got about 40 minutes left.
Okay, 40 minutes, let me move on. Okay. So it says that the true intention was a reconciliation with Great Britain, and that once that's done, this charter, this constitution will be null and void and inviolate. Didn't that just what it say?
Mm-hmm.
It won't be in effect no more. So why do I come to this conclusion? Let's come here. Crown Colony. History. Early English, read that for me. Who was reading?
I was.
Read, brother.
Right. Early English colonies were usually established and administered by companies under charters granted by the monarch. The first royal colony was the colony of Virginia after 1624, when the crown of the Kingdom of England revoked the royal charter it granted to the Virginia Company and assumed control of the administration.
Stop. Okay. So the Virginia Company charter was revoked because there are companies dealing with the crown colonies. It just said it. Crown colonies were companies. And said the companies, when you hit companies, go to joint stock companies.
Point of interest. So can we safely say that the fact that the states were, or the colonies' name returned to states, that means that the states themselves are still colonies, is the reason why they don't need a so-called Articles of Incorporation, because Articles of Incorporation is going based off of the original charter.
Yes, exactly. Because they were all falls under this.
Joint stock companies.
Joint stock companies. You come right here. Constitution. Now the true intention was to go back to Great Britain, but look at what they did. Read this right here. Both of these, all three of these, all four of them. Article 9, Article 10, Article 11, and Article 12. Read that, Brother Means.
Okay. That the governor and council, seven walls shall be a quorum, be the court of appeals, in the last resort, in all clauses of law, as heretofore, and that they possess the power of granting pardons to criminals after condemnation in all cases of treason, felony, and other offenses.
Stop. Now, who was head of the crown colonies? The governor, right?
Governor, yes.
Okay, so we're still, at this time, these are colonies. These ain't states. They amended the Constitution in 1777 on September 28th, right here. The legislature of New Jersey amended the Constitution September 20th, 1777 by substituting the word state and state for colony and colonies. So before 1777, these were colonies, right? Now let's go back to 10. Continue to read, Brother Ming. I'm sorry. Hold on, I got it. All right, there we go. Go ahead.
Okay. That captains and all other inferior officers of the militia shall be chosen by the companies in the respective counties, but field and general officers by the council and assembly.
Stop. Okay. Now you just told us in the original Constitution of New Jersey that the captains and all other inferior officers, when you say inferior officers, if the governor is head of it, then that means Supreme Court is inferior as well.
Mm-hmm.
It just said judges in inferior courts. Read 12.
12. That the judges of the Supreme Court shall continue in office for 7 years. The judges of the inferior court of common pleas in the several counties, justices of peace, clerks of the Supreme Court, clerks of the inferior court of common pleas and quarter sessions. The attorney general and provincial secretary shall continue in office for 5 years, and the provincial treasurer shall continue in office for 1 year, and that they shall be severally appointed by the council and assembly in manner aforesaid and commissioned by the governor, or in his absence, the vice president of the council, provided always that the said officers severally shall be capable of being reappointed at the end of the term severally before limited, and that any of the said officers shall be liable to be dismissed when adjudged guilty of misbehavior, by the council or an impeachment of the assembly.
Okay, let's go back to the Constitution. All right, now it says the captain, the governor is head of the last court of resort. That's the same thing that the Supreme Court does, is a last court of resort. So what the governor did was create a de facto court of law, ill-defined, which is Article 12, when he's actually the real court.
Right.
And he's the one who runs the government, which are nothing more than militias chosen by companies. Why? Because we just read the definition of crowns, colonies, and what they said they were. Companies.
Companies. Yeah.
All right, so that takes us to this. Joint stock companies. And joint stock companies, which one were Virginia Company, the South Sea Bubble Company, and all these companies had a hand in slavery. Enslaving the English heirs and successors. All right, so this brings us to the concession agreement. We're gonna head through this. How much time we got? Archbishop?
15 minutes.
All right. You can read this. This is the concession agreement of lower property of the province of New Caesarea, New Jersey, to and with all in every adventure and all such as shall settle or plant there in 1664. Now, under New Jersey Revised Statute 46:3-1, all the feudal tenure up to 1664 and after 1664 has been abolished. Under 46:3-6, the land is no longer feudal, but allodial. Under 46:3-10, it says all common recovery has been abolished and all entail has now been taking place. And entail is land that's held in the trust for the heirs. Now read what they stated in the concession agreement before it was surrendered back to the crown in 1702. That was the original charter of New Jersey, which was the concession agreement, and the rules as stipulated in this concession agreement was fixed. It was fixed. It didn't mention anything about Great Britain. It didn't mention anything about nobody but the Kingdom of England. How we know that? Let's read it in our closing. Start right here. Brother Mings.
Okay. Item that the governor, councilors, assemblymen, secretary, surveyor, and all other officers of trust shall swear or subscribe in a book to be provided for that purpose, that they will bear true allegiance to the King of England, his heirs and successors, and that they will be faithful to the interests of the Lord Proprietaries of the said province and their heirs, executors, and assigns, and endeavor the peace and welfare of the said province, and that they will truly and faithfully discharge their respective trusts in their respective offices, and do equal justice to all men according to their best skill and judgment, without corruption, favor, or affection, and the names of all that have sworn or subscribed to be entered in a book. And whosoever shall subscribe and not swear, and shall violate his promise in that subscription, shall be liable to the same punishment that the persons or may be that have sworn and broken their oaths.
Stop. You reading the book of life right here.
Yep.
You reading the book of life right here. Those properties are telling the United States that Benjamin Franklin's son, William Franklin, said that what y'all doing is a violation of the laws or the authority that were prescribed for us by the concession agreement, because all this land went back to the crown in 1702. Continue to read.
Okay. It's that all persons that are or shall become subjects of the King of England and swear and subscribe allegiance to the King and faithfulness to the Lord shall be admitted to plant and become free men of the said province, and enjoy the freedoms and amenities hereafter expressed, until some stop or contradiction may be made by us the Lords, or else the governor, council, and assembly, which shall be enforced until the Lord see cause to contrary. Provided.
Did y'all hear what that say? Did y'all hear what that said? Until the Lord find contrary that the governor has violated his oath. Let me show y'all something right now. We don't play the King's Bench. 1 second. Stop sharing before we go on. This is how we get there. Where is that? I did this in 2 days. Give honor to Archbishop and the Queen for assisting me. Can everybody see that?
Yeah. Yes.
All right. This is a civil complaint we filed for violation of the civil rights for us as members. ETI, I mean all of us, and your king, against the governor, Phil Murphy, for violation of English subject civil rights under English common law pursuant to New Jersey Revised Statute 10:5-3, pursuant to Title 22 United States Code Section 6401. Trustees and members, that's who we are, members. All right, I'm just gonna read this real quick. We read this the other day for all those who were here on that emergency call. This is the table of contents. Brief statement of the facts. Violation of the plaintiff's civil rights, origin of the common law, province of New Jersey, concession agreement, July 2nd, 1776 Constitution, reception statute, the violations of the common law, which is the change in the common law. Claim 1, citation of revision New Jersey by Statute 48(1-2). Claim 2, types of citizenship, everything we discussed today. Argument 3, definition of citizenship, Title 14, the 14th Amendment pursuant to United States Code 8, Section 1101. Argument 4, subject versus citizen. Argument 5, the difference between just so and versus just sanguineous. Argument 6, violation of the public trust doctrine. Argument 7, land acquired by municipalities held in the trust. Second, violation, breach of the common law, legal fiction of unpublished pursuant to Rule 1, column 36.3. We arguing the difference between unpublished and unpublished case law, which they use to dismiss majority of our cases because we don't know the difference. Conclusion, res judicata and controversy doctrine, which is what I just stated. Most of the arguments brought forth before court are already decided based off controversies that were already tried before court, based off the conclusions, based off those opinions. But most of those opinions are not Statutes because they're not based off the Statutes doctrine that's rooted in the common law, as stated versus Smith versus Alabama, which stated that there's only one common law, and that's the common law of England, which was adopted by all the several states and adopted as their local laws and the subject to some alterations that are provided by the statute. So based off that, we got a clear-cut case. And look how many pages this mug is, 55 pages. I didn't miss not one issue. Everybody, this is what we will be reviewing on Sunday school once everybody gets a chance to review the document and as a whole. So let's go back to where we were. In closing, all right, continue to read, Brother Means. Did we hang up? Oh, let me see.
There's nothing up there just yet.
Second. All right, here we go. Where were we at?
I think we were at that no person qualified.
Go ahead.
Okay. That no person qualified as aforesaid within the said province at any time shall be any ways molested, punished, disquitted, or called in question for any difference in opinion or practice and made of religious concernments, who do not actually disturb the civil, disturb the civil peace of the said province, but that all and every such person and persons may from time to time at all times freely and fully have and enjoy his and their judgment and conscience and masters of religion throughout said province, that they have that behaving themselves peacefully and quietly, and not using this liberty in lasciviousness, nor to the civil injury or outward disturbance of others, any law, statute, or clause contained or to be contained usage or custom of this realm or of England, to the contrary thereof, in any wise notwithstanding.
You hear that? It's notwithstanding. So that means that that Constitution of 1776 is notwithstanding. Why? Because this land was surrendered back to the crown by the ones who wrote this document. Why? Read the next paragraph. They recognize who they was.
That no person may be taken by our heirs or assigns for, or by reason of right, of patronage or power of evidence, granted by the Majesty's letters patents, unto his Royal Highness James Duke of York, and by his said Royal Highness unto us thereby to infringe the general clause of liberty of conscience aforementioned.
Stop right there. What you just read in that paragraph right there, in that sentence, what was the key word that they just mentioned in reference to citizenship, in regards to their rights, in regards to this charter, which is based off their rights granted to them as English subjects? What's that key word that made the distinction between them and this charter and us on this bench right now? 2 words.
Letters patents.
Give that man a hand clap. Give that brother a hand clap. He let you know right now that that letter patent says what? Denizens.
Dennis.
Let's go read the definition again. Denizen. Read what it is, Brother Means.
Denizen is an obsolete or defunct process in England and Ireland, and later the Kingdom of Great Britain, the United Kingdom, and the British Empire, dating back to the 13th century, by which an alien foreigner, through letter patents, became a denizen, thereby obtaining certain rights otherwise normally enjoyed only by the king's or queen's subjects, including the right to hold the land.
Okay.
The denizen was neither.
So right there tell you that they ain't the owners to this land because they just admitted they got a letter patent by the king.
Right.
They don't have the right to this. Read the last paragraph and close.
That the inhabitants being freemen or chief agents of other provinces, aforesaid, do as soon as this or our commission shall arrive, by virtue of a writ in our name by the governor to be for the present, until or seal comes, sealed and signed, make choice of 12 deputies and representatives from amongst themselves, who being chosen are to join with the said governor and council for the making of such laws, ordinances, and constitution as shall be necessary for the present good and welfare of the said province. But so soon as parishes, division, tribes, and other distinctions are made, that then the inhabitants of freeholders of the several respective parishes, tribes, division, and distinction as foresaid, do by our writs under our seal, which we engage, shall be in due time issued annually to meet on the first day of January, and choose freeholders for each respective division, tribe, or parish to be the deputies or representatives of the same, which body of representatives, or the major part of them, shall with the governor and council aforesaid by the General Assembly of the said province, the governor or his deputies being present, unless they shall willfully refuse, in which case they may appoint themselves as president during the absence of the governor or the deputy governor.
Okay, so it just said that either, where's that? It says that represent. Yeah, so right here, that then that the inhabitants or freeholders. You hear that? So right there it says that, but soon as it says the inhabitants of being free men, not freeholders. The freeholders is the ones who's occupying your government, now called the Board of Commissioners. It said that the inhabitants being free men, not freeholders, being freemen or chief agents to others of the province aforesaid. So we the chief agents do as soon as it's our commission should arrive by virtue of a writ in our names by the governor to be for the present until our seal comes, seal and sign, make choice of 12 deputies are represented from among themselves, who being chosen are joint with the said governor and council for the making of such laws, orders, and constitution as shall be necessary for the present good and welfare of said province. But as soon as the parishes, divisions, tribes, and other distinctions are made, that then the inhabitants or freeholders of the several respective parishes, tribes, and divisions, distinctions aforesaid, do by our risk under our seal we engage shall in due time issue a newly meet on the first day of January and choose freeholders for each representative division of tribe, blah, 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 blah. So we didn't do that for ourselves. They did it for us. But they didn't do it as prescribed according to this contract called the concession agreement, because it must be done based off the allegiance made between the king and his subject, which they were by, as they said, letter patent. I wasn't by letter patent. We were the heirs and successors. They clearly stated in this document the difference between the heirs and successors of England and the heirs and successors of those who descended from the proprietors under what they call the land grant, i.e. do it as citizens, which makes them aliens. So the only way out of this is understanding the charter, because the charter is the authority. And under 16:43-1, 16:1-43.7, 8, and 9 of the New Jersey Revised Statutes governing constituent corporation, through our certificate of incorporation, all the laws, rights, immunities, privileges, charter rights, etc. that we had in our constituent corporation going back to time immemorial, back to the English Church of England, we have now through our certificate of incorporation, because none of those rights were incorporated into any other company going back to the Crown colonies. Why? Because the land was held to the Crown, and the Crown, the United States became successor of, which was encompassed based off their inhabitants, which were freemen, and the freemen were those who were the heirs and successors by way of birthright under the blood. The only way you can get that is to go back to the Crown, because the concession agreement surrendered it back to the Crown. And who represents the Crown? The inhabitants. We just proved they ain't the inhabitants. They're foreigners. So this is that charter to disqualify the one they created in 1776, which was created by way of a presumption that they declare off their own, but not delegated by the legislation, which is this charter, i.e. the Constitution called the concession agreement. That was the standard. This right here, it said that anyone who tricked the proprietors in lieu of the original agreement granted by His Majesty on the letter patent will remain null and void, or to none effect. Now, if you go a little further in this charter in closing, you'll see the assembly, which assembly are to have the power. It also makes distinction between the governors, which is counts before express. It speaks about for the better security of the properties of all the inhabitants, and the planting of the said provinces may be more speedily promoted. All that deals with the inhabitation of this particular territory going back to time immemorial, when it was colonized by those people known as the proprietors, by grants given to them in lieu of what we call colonization. But as we know, that colonization doesn't have to note to hereditament, because you don't have the right to the property. Why? Because you're corporations, your companies, as proven in this lecture. So with that, I'll close out and give my queen the last voice, and lieu of all those who, at the sound of our voice, have listened to this marvelous lesson that I see is the key to understanding our position in regards to our political status as citizens in lieu of us being subject to the King of England, and now citizens of the United States, which is a form of digitization by letter patents created by those who got away from the original identity as colonies by way of the change of the names from states to colonies in 1777, September 20th. And with that, I digress. Queen.
Another beautiful lesson from the King. We talked about the Crown Colony and Owen versus the City of Independence, Paul versus Virginia, Thompson versus Zirko. And we went over the agreement of the Lord Proprietors again. But I just find it beautiful how, the king is putting all this information together. And like he said, the governor has to be held accountable. And we have to hold these officials to their oath and duties. And with that, I digress.
Well said, Queen. Well said, Queen. Archbishop.
There you have it, brothers and sisters from the Kingdom of England, Empire of Albion. The King has laid out once again a marvelous lesson that's even more concrete for you to be able to pull together from our previous lessons, based off of what we have presented today. It's showing you, you know, whatever you do and decide to be, it better be English, because if not, you're claiming to be a so-called citizen or property of the so-called municipality. Walking around and putting your head in the sand, that's technically acquiescence, you know. That's just telling us that you don't want to be who your foremothers and forefathers were. They already got everything set up. It's already etched in stone. We just recovering or uncovering what Supreme Court has already spoken about. Just like the King said, res judicata. A lot of these things that, you know, many of us are going to try to see others continue to keep trying to do. It's just going to be used based off of them utilizing what we call unpublished law or unpublished opinions. And those unpublished opinions are only used for that case, and they can never be used for any other case. So if that's the situation that we're dealing with, then that means that even the situation with this case is only going to be for us, because no one else is going to be able to use it if ruled in our favor, which it should be ruled in our favor. Once again, because we're not only showing you who we are going back to time immemorial, but we're utilizing their own statutes and codes of ordinance that's showing you that what we're doing is applicable today for our salvation. And if you don't bring yourself back into the church, then unfortunately you're claiming yourself to be a ward of the state, and there's nothing we can do for you. So with that being said, once again, great job, King, for bringing this marvelous lesson, as well as Queen. Always been by his side to keep you motivated, for him to continue to keep doing his great work as the head and supreme power of the Third Temple English Church of England, as well as heir agnatic succession from the Kingdom of England. And as we see, we're going to continue to keep condensing or consolidating this information, because right now we're dealing with a time which we call a state of emergency for those lost English heirs who have yet to figure out who they are. And right now, like I said, time is of the essence, and your grace period is coming to an end. So with that being said, I digress, and I leave the rest of the closing to C.A. Murphy from the Noble House of Murphy, as well as our other brothers and sisters from their respective houses. Peace and love.
Well said. Well said, Archbishop. C.A.?
Oh, marvelous lesson. Peace and love, King, Queen, King's Bench, Council, heirs, successors, trustees, and those that are viewing and listening to the sound of our voice. To camel back on what the Archbishop was saying, those published and unpublished opinions are giving the corporate municipalities an unfair advantage as to their judgments or their conclusions, because they are qualifying and classifying everybody as a denizen as they are as U.S. citizens, which is a violation of due process of law, which is a violation of your status, as it were, when challenging jurisdictions. So it is proper to understand the difference in res judicata and what they're using as to qualify their judgment in lieu of their letter patent or certificate of incorporation. So it is an excellent delineation of explanation of our vast estate, its true heirs and successors, and the duties that fall upon the municipalities and what they're doing in violation. And all of it is a form of subrogation to our estate. So the heirs and the true heirs, please stand up as we are here and now. I'm going to review all things that I've heard and continue to practice perfectly and perfectly practice this law and history that we study here in the inner temple, middle temple, and outer temple. So I digress. I trust all is well. And I look forward to continuing this marvelous work that we do in communion with each other. Peace and love.
Well said, C.A. And in lieu of what Archbishop and C.A. said, it's very important to consider our situation in regards to corporation and the term denotes the citizen. Because as we just read in Paul versus Virginia, it clearly says corporations are not citizens. But the case was superseded or appealed, overruled to allow corporations in lieu of commerce. They allow corporations to become citizens in lieu of commerce, but that case said corporations were not citizens. So that shows you that if they overruled it, that shows you that those sub-citizens who are now identified as corporations are being used for the purpose of commerce. Exactly. Because prior to that case, citizens and corporations were not synonymous, but now they are. And we can see that in the diversity of jurisdiction in regards to the term legal person. All right. Brother Burgess from House of Burgess.
Greetings, family. Can y'all hear me?
Yes.
Well, I appreciate the way that you break down the origins of where we stand at and the difference between them. And where else do I want to go with it? Us being subject to the crown and not citizens to the state through corporations. So that's very vital for us to understand. And I do get that more and more every day, and understanding my powers, our powers as heirs and successors, as English nationals. So I definitely appreciate that, King.
Yeah, well said.
In the bench.
Like I said, I can't stress enough about impacting on us understanding the situation concerning diversity, because the state and the United States law protect our issues concerning our diversity as citizens. We have to show them that their presumption on the determination of our citizen was based off the identity of a legal person, conferred by way of you being born in a particular area, which is how the court established personam jurisdiction. But you don't have personam jurisdiction because you haven't established my citizenship. You're assuming my citizenship, but you have not determined it. And that's the diversity issue. If you determine it, then that's automatically discrimination because of under color of law. All right, well said, all those who spoke prior to that. Let's have Brother Moonday. I ain't seen you in a while, so let's hear from you, brother.
Yes, it's a marvelous. That's the big greetings, everybody. It's a marvelous.
Greetings.
Like you said, Campbell backing on what he said about the.
You're breaking up. Speak a little louder.
I said Campbell backing off of what he said about the diversity of citizenship, about being a subject and a citizen. I finally understand that part now. I wasn't getting it first, but
well said. Very important to understand that, because that's the case. Continue.
Yeah, so you enlighten me on that today, as well as just soil, being a corporation and so at the same time. I wasn't getting that at first either, but I hear this more and more.
We didn't get that last part. Speak it to the mic.
I said I'm getting it more and more. I got this thing on my ear.
Okay.
That's why. But I said I'm getting it more and more as we progress in our studies, and I look forward to learn a lot more. Study.
That's good. That's good. A lot of times
I'm a little behind.
Well said, Brother Monday. You were broken up, but we got the drift of what you were saying. And I'm pretty sure, based on everyone's perception of your take on it, is pretty much how they feel. And before I let Brother Scott go, I want y'all to take a look at the screen when it speaks about under this case law. This is Farmers Mill Fire Insurance Company of Salem versus New Jersey Property Liability Insurance Company, which is all deals with commerce. All right. The key point about this is what they say. Now, we're using common law to support our argument, but look what they say about statutory law. It says, when interpreting statutory language, a court primary goal is to give effect to the legislative intent. looking first to the statute's plain language and returning to a stringent source such as legislative history. Now, what the Smith Alabama says that the common law must be looked in light of the history of the common law, which we know derives from legislation. It says that such legislative history in the event of ambiguity. This case hinges on the effect of the 2004 PLIGA Act amending to the New Jersey revised statute annotated 17:30A.5 on New Jersey's common law jurisprudence, specifically the method established in Owens, Illinois, for allocating limit liability among insurers in context of ongoing environmental contamination occurring during successful period policies. The methodology known as the continuous trigger doctrine allows courts to treat progressive injuries or damages occurring throughout the contamination period as an occurrence triggering every insurance policy on the risk. In order to properly allocate remediations costs, the Owens, Illinois court adopted a proportion scheme which allocates losses among insurers on the basis of years of coverage and degree of risk assumed, blah, 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 blah. We go down to the most important aspect of it. The PLIGA Act, which should be liberally construed to achieve its purpose, was passed in order to mitigate the financial distress to insurer and claimants resulting from an insurance company in insolvency, and creation of guarantee association to stand in the place of an insolvent insurer in order to conserve resources and achieve the PLIGA Act of core purposes. The guarantee insurance company responsibility to pay the insolvent insurance claim is limited. It's limited. The conservation objective is evident in New Jersey statute annotated 17:30A-12B, which requires a claimant to exhaust the policies of solvent insurers prior to seeking statutory benefit. At the time of the Sarah's decision, neither the PLIGA Act nor the Guarantee Fund Act define exhaustion. In 2004, the legislature amended both acts, defining exhaustion in the context of the continuous trigger cases involving progressive injury and property damages. The PLIGA Act amended to New Jersey statute annotated 17:30A-5 states that exhaustion occurs only after a credit for the maximum limit under all coverages, primary and excess, if applicable, issued in all other years have been applied. Under the most straightforward plain reading of the provisions, other coverages refer to policies issued by a solvent insurer, thereby requiring exhaustion of the policy limits issued by solvent insurers before obliging the guarantee association to pay statutory benefits. Since the legislator is presumed to be aware of the decisional law of the state, it is reasonable to conclude that the 2004 amendment was intended to reverse the result in SARE. This conclusion is consistent with the principles of guarantee association is an insurer of last resort. In the dissent, the legislative enactments are never subservient to the common law. The 2004 amendment to the PLIGA Act takes precedence over the common law proration scheme enunciated in Owens versus Illinois. The definition of the exhaust in the New Jersey statute annotated 70:30A-5 as applied to New Jersey statute annotated 17:30A-12B is clearly intended to make the guarantee association the insurer of last resort and continuous trigger case involving progressive injury and property damages arising from environmental contamination. Insurer must exhaust the policy limits of solvent insurers prior to the applied guarantee association for statutory benefits. So in full context of what they are saying is that the common law legislation that was used in lieu of recitation of the persuasive intent does not override the legislative intent as established by the legislation, and which we're leaning towards. But most of the so-called judges who review our cases shy away from the statutory law or legislation and depend on common law, which is persuasive in nature, but not binding on courts if you don't know it and if you don't know the intent and what they're using. Because most cases that are used and the opinions that are based off are not binding in the court because they're not based off any prejudice, because the prejudice that they should be based off is the common law of England, which was adopted by the states as decided it's Smith versus Alabama. But it must be read in light of the common law history and reference to the history of the people in which the common law originated from. So because there are no people in lieu of the common law to review it in light of that history, this is the reason why we find ourselves in the position we're in today as a result of the stare decisis, which is based off non-presidents. So in that, let's move on to other closing remarks, and that will be Sister, who would that be? Sister Harris from the House of Harris. Excuse my long-windedness. Greetings.
No, you're giving us great knowledge, so I appreciate that, you and the Queen.
Thank you.
For your hard work. And sorry for being late today. But I agree, I love how you was pointing out, I have to go back and study this, but you was pointing out how, what the crown colonies were and how the New Jersey was given back to the crown in 1702. Let's see, and that we have the crown, let's see, I have so many notes here. The governor, you said something about the governor has to be accountable. So we have to show this to them. So you have done that, you and your wife, you and your wife, the Queen, in the article that you had just presented, that you said we'll all go back and read. You presented every detail of how that goes back to the crown land and the king. So I appreciate that.
Well said. Well said. Very observative in your dissertation in lieu of your argument, and that's each and every one of us should be or should endeavor in lieu of grasping at those straws that can be stated but overlooked so many times. So well said, Sister Harris from the House of Harris. And I know that Sister Countess Allen and Countess Walker will follow you shortly in that dissertation that you gave in regards to their reflection. Countess Allen. Or did you go already?
No, I haven't gone yet.
Okay, go ahead.
Thank you once again for another marvelous lesson. We're hitting it hard on our ancestry and in terms of our citizenship, which goes all the way back to the dissolution of the monasteries, like you had spoken of earlier under King Henry VIII, with the dissolving of our estate, and how you have carefully detailed how we're going to get it back through these statutes. Once again, you touched on the concession agreement, Wong Kim Art, once again, speaking on nationality, which is with respect to nationality as being just solely. Denization with the letters patents that was given to the aliens to obtain property here, and touched on the diversity of parties, and Owen versus City of Independence. This one actually was a new one for myself. I wasn't aware of this one. So I'm just definitely going to have to go back and review a lot of these statutes that were presented today. Paul versus Virginia as well. And
Thompson versus Zirk.
I'm sorry.
I think it was Thompson versus Zirk.
Thompson versus Zirk.
Yeah, Zirke.
Oh, I didn't write that one down. I got Paul versus Virginia, 75 US 168. That one you touched on as well.
Yeah, but this one is Thompson versus Zirkel.
Oh, okay.
Zirkle.
Okay, I got that one.
All right.
Okay.
Okay, well said. You continue.
Thank you. I digress.
Okay, well said. Well said. Sister Walker from the House of Walker.
Greetings, King. How are you?
I'm blessed as always. Good to have you here amongst us, family.
All right. Actually, the lesson, everything that I think about, and when I want to write something up, you actually give it to me. All the notes that I took today, in the new case law, you just kind of walk us down with our citizenship and how we are English nationals and we're just Sanguilis and not just Soli, and how we can write that up in elementary terms and present that. So only you could do this, King and Queen, and I'm very grateful for all the lessons, and I can't wait for this to get uploaded so I can put it on repeat. And you did a great job, and this was a powerful lesson as usual, King.
Thank you very
I
much.
digress.
Thank you very much. I really appreciate it. Like I said, my job is not to just get up here and teach. What's the point of teaching when no one's learning? So I'll continue to go over it until I feel as though in my heart that what I'm hearing being regurgitated by you, it sounds smooth into my soul. And that's only done by hearing y'all speak in lieu of your dissertations. And I'm very well pleased to hear the frequency that resonates with you in lieu of you and bouncing off those nerve centers. That's very, just like music. We know what type of music we like to hear. It's a frequency. So if the frequency or the vibration doesn't hit us right, we kind of shy away from it, and y'all had many chances to do that, but you're still here. So I know the music is good to your ear, and I thank you for even giving me ear to that. So thank you very much for that dissertation. Any other countesses we have? I think this is all the countesses. China's still there? You still boo-boo? I think she done got off. Yeah, she done got off.
Yes, she got.
All right, let's have Brother Greg from the House of Greg. Brother Burgess, you went already, right?
Mm-hmm.
Okay, Brother Greg from the House of Greg.
Greetings, King and Queen. Another wonderful lesson, like you always do. It was moving back and forth pretty fast, but I was able to take some notes. And what stood out to me the most was how the crown was a corporation soul. And it made me kind of tie things together and realize that, correct me if I'm wrong, that since the English Church of England is a corporate soul, and it holds the crown, which we hold allegiance to, that make us natural born subjects. Am I correct about that?
Man, I couldn't have said it. That's like music to my ears.
So,
well said.
So
that's well said. That's how you should talk.
So
that's how you should talk. Because remember what they say, anything you say will be held against you in the court of law. So you don't change for them because they ain't gonna change for you. It's mine versus yours. I'll improve my citizenship through my certificate of incorporation. If you don't allow me to stand on my citizenship through my certificate of incorporation, then that's a deprivation of right under color law. Why? Because you deprive me of my nationality. And nationality denotes my nation, and my nation only recognized through the certificate of incorporation, just like the United States was recognized as a nation through their certificate of incorporation, which is null and void now. Why? Because the reconciliation has been Great Britain has been reconfirmed by way of our certificate of incorporation as established in the statute. There's no way they can get out of this. So well said, Brother Greg. Well said. Brother Scott from the House of Scott.
Can you hear me, King?
Yes, I can hear you, sir.
Always a great lesson.
Thank you, sir.
But King, I have two things.
It's 3 o'clock.
The first thing that stood out to me was the declaratory and injunctive relief. And I heard Archbishop Belmont mention earlier that our end goal is to have these courts rule in our favor. So I got confused then because I wasn't sure exactly what he meant, but I looked at these definitions as well. So are we looking for a dismissal? Are we looking to be pushed to the Supreme Court because they're the only ones who can give us remedy? Or does this still put us inside, I guess, a type of a color of law realm?
Yes.
Looking for relief.
Yes, you're in the color law realm because of the color of law that they're using, which does not protect you. The state laws protect you in lieu of your citizenship. You're not a citizen of the state because the state's not considered on lieu of diversity issues because all the citizens are incorporated in the state, and that's through corporations.
Mhm.
You know what I'm saying? So the case in point is grounds for dismissal, because as it's just stated right here, let me just go to it. Thompson versus Earth. A claim may be dismissed only if it appears beyond doubt that the plaintiff can prove no set of facts. Now, most of the time when we're being brought into court, who we are, the defendants, and the complaint, right?
Right.
Because it's being brought by a plaintiff. Now, I said a claim may be dismissed only if it appears beyond a doubt that the plaintiff can prove no set of facts in support of its claim. Now, they ain't talking about us, they talking about the municipality, right? Now, you motion to dismiss complaint because the municipality lacks jurisdiction. Why? Because they only have a claim under color law of the state.
Right.
And it said a claim may be dismissed only if it appears beyond a doubt that the plaintiff can prove no set of facts in support of its claim, which be entitled to him to relief. Allegations of a pro se complaint are held less stringent standard than formal pleadings drafted by a lawyer, which is the one who's bringing you the case in court as the plaintiff, i.e. the prosecutor. Then it goes on down and says further, in order to state a cause of action under 42 United States Code 1983, which deals with separation of rights under color law of the statute, which is being done by the plaintiff, i.e. the municipality. Because as we just read in Owen versus the City of Independence, municipalities are in violation of Title 42, 1983. And they don't have any liability in lieu of Title 42, Section 1983. Why? Because they don't have any privileges and immunities, which you have as a citizen, which they deprive you of because they're using color law of the state.
Exactly.
So if you let them know that if this law is not the law of the state, then that's ground for dismissal because you deprive me of the law, of protection of the law that comes from the state. They got you in on the orders. New Jersey statute annotated. That's unconstitutional because it's not construed to the legislation. How are you going to say you holding me in this on the state statute when you're a municipal court? I don't care what you say in the name of the state. You're not the state. Because the state got a state constitution, which apparently you're not using this courtroom, because if you was, as Smith, Alabama said that, it must be construed to the common law. And this is not the common law, so you just state the claim which relief can be granted, which is ground for dismissal. You failed to state the claim where relief can be granted under the common law because you adopted the common law as it's said by the case law. But if you don't grant, I'm going to appeal, and I'm pretty sure they'll agree in my favor. Why? Because it's their dice. It's prejudice. That's your argument. You're staying your argument. What you're letting them know that if you don't move to dismiss this case as the plaintiff, then I'm gonna hold you in violation of Title 42, United States Code, Section 1983. And what that said, you deprive me of protection as a citizen by the state constitution. What state constitution? 1776, Article 22. The common law was adopted by all the several states. And you ain't the state, you're a municipality.
And point of interest.
Because now I'm going against your bond.
Understood.
You divided the public trust. Every one of y'all in your municipality, look up the municipal codes of your state.
Of your territory.
Of your territory. That's the government that you're subject to.
And point of interest, that's the reason why we say always speaking in the name of the church, because remember, our laws, common law of England is our church law. So if they deny you the common law of England, they deny you your religious rights, which is a big no-no in their world.
It's a big no-no. That's I just read the statute, I forgot what it was. All right, so like we said, if they fail to state a claim, then that's ground for dismissal. And the claim that they stated was a claim that's rooted in color law, color statute. If that statute don't construe itself to that constitution, then there's null and void. It's capricious and outside of the law, which they can be held liable for. Why? Because you're a citizen protected by the state. You don't say you're a citizen of the state. You just say you're a citizen protected by state law. Now it's a diversity issue now because they're saying you one of their citizens because they got you in the municipal court. This is not a state court. The state court is the superior court. So if you're gonna hold me in this court, then I'm motioning to remove it to a state court where I can get remedy under the common law, because that's where the common law was adopted in all state courts. Now municipal court, because it just said in case law that you're not, you're subject to, wait, let's just go to it. I wanted to keep hierarchy. On versus City of Independence.
All right, we gotta get ready to shut this down soon because it's getting.
Okay. Amenity with statutes common law where rational, blase. There's no traditional amenity for municipal corporation. If there's no amenities, that means you don't have any privileges and amenities. All right. So in closing, who else did let me get to Brother Scott. Did you go?
Yes, sir.
Okay. Brother Milligan, greetings, Noble. Greetings, Brother Milligan. All right. Brother Harris. Greetings, Brother Harris.
Greetings, my king.
Greetings. How you
And my
doing, class?
beautiful, I'm good, and my beautiful, wonderful family. I love you guys so much.
We love you
This
too.
lesson, and I say this in honor, it reminded me of being a child in elementary school when someone wanted something of yours and they had a gang of, and I say municipalities to come after you, but they didn't realize you had a big brother. That's what this lesson reminded me of with the laws, that you got a big brother behind you.
As always. Well said, Brother Harris.
Always. Yes.
We are our brothers and sisters keepers.
Yes. The
Yes,
laws
sir.
of England, as Archbishop told me,
Well said.
the English church is the most powerful on this planet.
You got that right, Noble. You got that
And when
right.
you come in with your English, they don't want to hear that. They don't want you to take their houses. They don't want you to take their life savings. So they hurry up and just dismiss it because they don't want nobody to know how powerful you are, because then they're going to ask you for their help.
Exactly. Exactly.
That's why they want to shut you up. Yeah, that's why they want to shut you up, and we're going to just dismiss it and we apologize. No, you're going to pay me. Give me my check too.
Yes, exactly right.
You ain't going to just dismiss it because you done took my time. You done took some of my life resources dealing with this mess.
Time is money and money is time.
Yes. And plus, I got to help my kingdom. So, yeah, you're going to give me some funds.
Well said. Well said.
I digress. I love you.
Thank you, Brother Harris. Appreciate your voice as well as your willingness to assist us even in your situation. Thank you so much.
You're welcome.
We have Brother Moonday.
I spoke already, but
okay. You spoke in closing already? Okay, all right. Well, last one is Brother Means, my gatekeeper.
Greetings,
I would
King.
like to
Brother Burgess.
say some numbers and information with two people.
Can't hear you, Brother Means.
No, that wasn't me. That was somebody else speaking.
Who else was that?
I think that was Brother Monday trying to speak.
Oh, okay, all right. What you say, Brother Monday?
I digress. I was seeing how to get in contact with everybody. On a day-to-day basis.
Yeah, Archbishop will get that information. We're planning a retreat upcoming soon, but we're going to make sure everybody's on board before we even start planning. So, like I said, stay tuned, stay in the loop, and that information we get out to you. In lieu of the time, we have last but least Brother Troy Means from the House of Means. Greetings, Noble.
Greetings, King's Bench, and all family members aboard. I thought it was a magnificent layout once again, especially the way you brought a full circle to the diversity factor that we're facing. I thought it was important the way you spoke of, I guess, the government per se, when they violated the Constitution, and in the violating of the constitutional rights, they violated the Charter, which is a contract agreement. And you have an offer and acceptance, and you have a consideration. This is the form of a contract. And in them violating that contract, they violate our rights to be, which is the deprivation. And when you deprive me of those rights, there are tort claims, especially speaking of the Title 42, Section 1983. This is important, which is a safeguard bodyguard of us being the church, being in a circle of people, of a government politic that protects us. They've confused us and kidnapped us, which is a term they use of adaptation through the Secretary of State. They try to use this as a safeguard for themselves, but the layout that you put in front of us for our defenses and of our state, being in the territory that we're in, them claiming us as their citizens, which we are subjects, hereditary through blood. So once again, I thought it was a magnificent layout and understanding to be able to use in our defense as a whole. Individually, there's no remedy. It has to be a unit, which is the nation that we come from. I wouldn't say much because I know we're pressed for time, and I just want to say I appreciate the way that you presented that in front of us, that we can go back and research and use these statute codes, laws in defense. Even in them writing their statutes and code, they contradict themselves and show the hang up of themselves. So there's justification in all of this.
Well said, Brother Means, from the House of Means. And in closing, as you can see on the face, Exhibit 6, you see the old Governor Murphy smile. And you see right here on Wikipedia, for all those who can go, it says Governor of New Jersey, great bread, word for word. Constituent instrument, New Jersey Constitution of 1776, July 2nd, on Article 9. He's the boss. That's the one we got to go to. We cut the head off the snake, the body will fall. And that's what I plan to do. So with that, I love you all. Thank you for your consistency, your studentship, and your field team, and your allegiance. And with that, Archbishop, you close out.
Once again, like I said, there you have it, brothers and sisters. You already know that there's only one place for salvation. We keep telling you each and every day, like I said, this is your religion. You know, what you do and what you pledge based off of your actions determines your true religion. Now you can either work for Caesar, which is Rome, or you can work for God, which is good. And you're going to work for God, which is good, you must be teaching this truth, and only truth can only be brought via having this information that's coming from the King's bench. So we love y'all. And once again, like I said, for you to be right, you got to be on the right path. Peace and love.
Peace.
Peace and love.
Peace.
Talk to you soon.